I will try that again. Justice Jafta, good morning. Ndumiso Luthuli for the President of the Republic of South Africa.
Thank you, Mr. Luthuli.
Good morning, Justice. May it please you, I appear on behalf of the second applicant, the EFF. My name is Bahia Baba.
Thank you, Ms. Baba.
Good morning, Justice Jefta. My name is Mule Mpakanyani. I'm for the third applicant, Amapungani Center for Investigative Journalism.
Thank you, Ms. Mpakanyani. This matter concerns enforcing the Executive Code of Ethics that was drawn up by the President of the Republic, acting in terms of the Executive Members Ethics Act 82 of 1998. The President published this code in July 2000 after consulting Parliament. The code applies to all members of the National Executive, including the President, and members of the Provincial Executive Councils. The method and procedure to be followed in investigating complaints relating to violations of the Code are set out in Sections 3 and 4 of the Act. Section 3 empowers the Public Protector to investigate breaches of the Code on receipt of a complaint. This provision directs the Public Protector to expedite investigations and submit a report on the investigation within 30 days of receipt of the complaint. But if the investigation is not complete by then, the Public Protector must submit a second report upon completion of the investigation. A report is submitted to the President if the complaint was against a member of Cabinet, a Premier, or a Deputy Minister. If the complaint was against the MEC, the report should be submitted to the relevant Premier. Upon receipt of the report, the President is obliged to submit that report together with his comments and description of the action taken against the culprit to the National Assembly. This must happen within 40 days from the date he received the report from the Public Protector. The Premier is required to do the same and submit the report to the relevant provincial legislature. However, Section 3 is silent on the procedure to be followed when a complaint is lodged against the President. But what is clear from this provision is that a sanction for the breach of the Code is imposed by the President or the Premier, as the case may be. Section 4 of the Act requires the Public Protector to investigate complaints on breach of the Code in accordance with Section 3. The complainant may be the President, a member of the National Assembly, or a permanent member, rather, of the National Council of Provinces, if the complaint is against a Cabinet member or a Deputy Minister. If the complaint is against the MEC, the Premier, or a member of the Provincial Legislature may be the complainant. Section 4 requires that the complaint must be in writing and that it must contain full particulars of the alleged conduct. Evidently, the power conferred on the Public Protector to investigate breaches of the Code may not be exercised unless there is a complaint from the right complainant. This means that the Public Protector cannot act on her own accord if she gets to know about the breach of the Code, nor can she conduct an investigation that goes outside the parameters of the complaint received. This is the legal framework within which this case arose. The factual background is as follows. On 6 November 2018, the President of the Republic appeared before the National Assembly to answer questions. Having answered the original question from the leader of the official opposition party, Mr. Maimane, a further oral question was put to the President. This question suggested the leader of the official opposition had proof of payment of the amount of 500,000 into a trust account called EFG2 on 18 October 2017. It was alleged that the payment was made to Mr. Andile Ramaphosa, the president's son. The leader of the official opposition also stated that he had a sworn affidavit from the person who made the payment, which stated that Bosasa's CEO had asked him to make the transfer for Mr. Andile Ramaphosa. He then asked the president, that is the leader of the official opposition, he then asked the president to set the record straight. Although in terms of the rules of the National Assembly, the president was not obliged to answer the question on the spot, he elected to answer it. In his answer, he said his son was running a consultancy business and that he had signed a contract with Bosasa, which the president himself had seen. However, it turned out that the leader of the opposition, in framing his question, had the facts completely wrong. The payment of 500,000 rand into the EFG2 account was not for the president's son, but was a donation by Bosasa's CEO to the CR17 campaign. When this error was brought to the president's attention by one of the CR17 campaign managers, the president addressed a letter to the Speaker of the National Assembly, informing her that the answer he gave in response to the oral question was inaccurate, and that the payment was a donation to the CR17 campaign. He said at the time he answered, he had no knowledge of the donation. It was this letter which led to 2 complaints that were lodged with the public protector against the president. The first complaint was submitted by the leader of the official opposition. It read, open quote, on 6 November 2018, during a question session in the National Assembly, I presented President Ramaphosa with the documentary proof of the payment and a sworn statement that alleges the money was intended for his son. The president confirmed that he was aware of the payment, but he had been satisfied that it was a lawful payment for services rendered by a consultancy firm owned and operated by Andile Ramaphosa. Subsequently, and on or about 16 November 2018, the president sent a letter to the Speaker of the National Assembly purporting to correct the answer he gave in the National Assembly 10 days earlier. In this letter of correction, the president reveals that the payment was actually a donation toward his campaign to be elected ANC president in December 2017. It is my concern that the set of facts related above reveal that there is possibly an improper relationship existing between the president and his family on the one side and the company African Global Operations, formerly Bosasa, on the other side. The nature of the payment passing through several intermediaries does not accord with a straightforward donation and raises the suspicion of money laundering. The alleged donor is further widely reported to have received billions of rands in state tenders, often in irregular fashion. It is further my concern that the president may have lied to the National Assembly in his reply to my question on 6 November 2018, close quote. These were the full particulars of the first complaint, as envisaged in Section 4 of the Act. Notably, from the text of the complaint, there are 3 concerns raised for investigation. The first was a possible improper relationship between the president, his family, and African Global Operations, formerly known as BOSASA. The second was the suspicion of money laundering. And the third was the possibility that the president lied to Parliament on 6 November 2018. While 2 of these concerns may be grounded in the code, the suspicion of money laundering cannot. This implies that the public protector ought not to have entertained it ostensibly in terms of Section 4 of the Act. The second complaint was lodged by the Deputy President of the Economic Freedom Fighters. In it, 2 issues were raised for investigation. The first was whether the statement made by the President in the National Assembly on 6 November 2018, to the extent that he had seen a contract between his son and African Global Operations, was true. The second was whether the President had deliberately misled Parliament in violation of the code. It will be noted that both complaints did not refer to the President's failure to declare donations to the CR17 campaign, nor did they raise concerns in relation to the affairs of that campaign as constituting a breach of the code, which was the legal instrument on which the complaints were based, whereas these complaints defined issues to be investigated by the public protector. In December 2018, and by notice, the public protector invited the President to submit a written response to the first complaint. On 29 January 2019, the President met with the public protector to submit his response. It was during that meeting that the public protector raised for the first time the issue of the President's failure to declare donations to the CR17 campaign as personal sponsorships under the code. The President disputed he was under a duty in terms of the code to disclose those donations. He said they were not donations to him, but to a structure within his political party, the ANC. In her investigation, the public protector also interviewed managers of the CR17 campaign and demanded from them disclosure of information on all donations to the campaign. But the managers declined on the ground that the only donation that was relevant to the complaints was the one made by the CEO of African Global Operations, that is the sum of 500,000 rand, which was paid into the EFG2 trust account. With regards to the 500,000 donation and the President's position in relation to the donors of the campaign and donations made to it, the 3 managers corroborated one another. They said donors were informed not to expect any favors and that their identities and amounts donated would not be disclosed to the President. They said the President was not involved in the affairs of the campaign and that he had no say on how the campaign spent the donations. The public protector also received evidence from Mr. Petrus Fenter, who effected the transfer of 500,000 rand into the EFG2 account on behalf of the CEO of African Global Operations. The same person that the leader of the official opposition had said he had an affidavit from, to the effect that the payment was for Mr. Andile Ramaphosa, the President's son. Mr. Fenter confirmed that he effected the transfer from the account of Mioto Trading, which was a company owned by him and his sister. He said an amount of 3 million had earlier been deposited into that account by Ms. Natasha Olivier, who was the company secretary of African Global Operations. Mr. Fenta and Mr. Olivier were the employees of African Global Operations. He said he was then instructed by the CEO to take the sum of 500,000 from that amount and transfer it into the EFG2 trust account, which he was told belonged to Mr. Andile Ramaphosa. In his evidence, the CEO, Mr. Gavin Watson, confirmed that the money was paid at his instance, but said it was a donation by him to the CR17 campaign. He disputed the evidence of Mr. Fenta on the identity of the beneficiary. He said he had been approached by one of the managers of that campaign with a request for a donation. The public protector also interviewed 3 attorneys from the firm called Eldenstein, Faber, and Grobler, which conducted the EFG2 trust account. Ms. Ronelle Grobler, who was responsible for that account, informed the public protector that she used to receive instructions from one of the CR17 managers for making payments from that account. The public protector also called for bank records relating to the EFG2 account, from which she confirmed that the sum of 500,000 was paid from the account held by Miyoto Trading into the EFG2 account. Those records also showed that an amount of 191 million rand was deposited into that account and that payments were made from it to several beneficiaries, including Ria Tender Trust and the Cyril Ramaphosa Foundation. It also appears that some emails were anonymously delivered to the Office of the Public Protector. These emails were in the form of hard copies. In her answering affidavit, the Public Protector confirmed that the authenticity of those emails was not established. She said, open quotes, "It is telling that instead of denying the contents of the emails, the President complains about how I obtained the emails to which I refer. I received many documents from anonymous whistleblowers. These emails were provided to my office anonymously and in hard copies. It is also for that reason that I have no metadata in respect thereof," close quote. This was a response to the President's allegations that the emails contained private information that was protected in law and which was unlawfully obtained by the Public Protector. But the Public Protector did not respond to the assertion made by the President that he, the President, was not afforded an opportunity to address the contents of those emails and that they appeared for the first time in the final report issued by the Public Protector. While none of the emails said the President personally benefited from the CR17 campaign donations, they contradicted the evidence of the campaign managers to the extent of the President's involvement in the fundraising of the campaign. Some of the emails showed that the campaign managers had asked the President to contact certain prospective donors for donations and thanked some donors who had already donated. But his response to such requests is not on record, nor is there proof that he received the emails on those requests. Of importance with regard to the emails in question is whether it was procedurally fair for the Public Protector to rely on information delivered to her office by unknown persons and without affording the President the opportunity to address that information. Having received the evidence outlined above, the Public Protector made a number of factual findings which became the basis of the remedial actions she issued. I shall now turn to those findings. The first finding relating to the question whether the President misled Parliament when he gave his answer on the 6th of November 2018. The Public Protector recorded her findings in these terms, open quote, President Ramaphosa on 6 November 2018, in his reply to Mr. Maimane's question, albeit defective in terms of the rules of the National Assembly, was misleading, as he also conceded in his correspondence to my office on 1 February 2019, and even in his subsequent letter to the Speaker of the National Assembly on 14 November 2018, where he sought to correct the incorrect information he had provided in the National Assembly. Consequently, President Ramaphosa's reply was in breach of the provisions of paragraph 2.3a of the Executive Ethics Code, the standard of which includes deliberate and inadvertent misleading of the legislature, close quote. For the breach of the code, the Public Protector ordered the Speaker of the National Assembly to refer the President's violation of it to the Joint Committee on Ethics in the Assembly. Surprisingly, the Public Protector also made a finding on whether the President had exposed himself to a situation involving the risk of conflict between his official duties and his private interests, or used his position to enrich himself and his son through business owned by the African Global Operations. This issue did not form part of the complaints she was investigating. Therefore, it was not competent for the Public Protector to investigate a matter that was not covered by the complaints which gave her the jurisdiction to investigate. This was compounded by the fact that under the same issue, the Public Protector proceeded to determine whether the donations made to the CR17 campaign were benefits of a material nature to the President, which he was under a duty to declare. She then concluded that by failing to declare donations received by the CR17 campaign, the President had breached paragraph 2 of the Code. The last issue on which the Public Protector made findings were whether there was an improper relationship between the President and his family on the one hand and African Global Operations on the other, due to the nature of the 500,000 payment passing through several intermediaries instead of a straightforward donation to the CR17 campaign, thus raising the suspicion of money laundering. Apart from collapsing the issue of improper relationship and the suspicion of money laundering into one, the Public Protector found that both issues were based on the way the payment of the 500,000 rand was made. Having found that the President has failed to declare donations made to the CR17 campaign, the Public Protector instructed the Speaker of the National Assembly to demand publication of all donations received by the President within 30 days of receipt of the report. The Speaker was also required to submit a plan within 30 days to the Public Protector. This plan had to show how the Speaker was going to implement the remedial action. The National Commissioner of Police was himself instructed to investigate an alleged violation of Section 11, Sub 3 of the Public Protector Act by the CEO of African Global Operations, who was accused of lying under oath. The National Director of Public Prosecutions and the Commissioner were each instructed to submit a plan describing how they were going to implement the remedial actions that required them to do investigations. These plans, too, were to be submitted to the public protector within 30 days from the date on which the report was issued. Dissatisfied with the findings made and the remedial actions taken, the President, the Speaker of the National Assembly, the National Director of Public Prosecutions launched a review application challenging the Public Protector's report. This report was challenged on the grounds of unlawfulness and irrationality. The Public Protector and the EFF opposed the review application. Amabungane Center for Investigative Journalism was granted leave to join the case. Amabungane asked the High Court to interpret the code as requiring disclosure of donations made to campaigns for internal leadership of political parties. Alternatively, it sought to challenge the validity of the code. The High Court delivered a comprehensive judgment on the matter within a period of a month. That court upheld the argument that the findings made and the consequent remedial actions were unlawful and irrational. With regard to Amabungane's case, the High Court interpreted the code and concluded that in its present form, the code does not require disclosure of donations made to internal campaigns for leadership of political parties. However, no decision was taken on the constitutional challenge against the code. The Public Protector, the EFF, and Amabungane were unhappy with the outcome and sought to appeal directly to this court. We were satisfied that these parties met the requirements of a direct appeal. The issues that arose are similar to those that were raised in the High Court. They are A, whether the Public Protector correctly found that the President had misled Parliament in breach of the code. B, whether the President had a duty to disclose donations made to the CR17 campaign and whether the Public Protector competently investigated this issue. C, the Public Protector's competence to investigate the affairs of the CR17 campaign. D, whether the Audi principle applies to the process preceding a decision on remedial action. E, whether the remedial actions taken were lawful, and F, whether the High Court rightly declined to adjudicate Amabungane's constitutional challenge. Each of these issues was considered separately by this court. The first issue considered was whether the President misled Parliament. The inquiry into this issue was partly factual and partly legal. The standard for determining whether there was a breach is to be found in paragraph 2.3a of the code, which reads, open quote, members of the executive may not, A, willfully mislead the legislature to which they are accountable, close quote. In plain words, the code prohibits members from willfully misleading the legislature. The member concerned must have intended to mislead by furnishing incorrect information to the legislature. The underlying reason for this qualification is that members of the executive rely on information given to them by departmental officials, the correctness of which they are not in a position to verify. The evidence placed before the Public Protector did not establish willfulness on the part of the President when he answered the question by Mr. Maimane on 6 November 2018. In fact, it appears that Mr. Maimane himself was not aware that his question was factually incorrect. He thought that the payment of 500,000 rand was made to the President's son, Hence, he was concerned about the improper relationship between African Global Operations, whose CEO had paid the amount, and the president and his family. At the time the answer was given, all parties concerned thought that they were dealing with a payment to the president's son. It was only after the parliamentary session that it was brought to the attention of the president that the payment into the EFG2 trust account was a donation to the CR17 campaign. And he sought to correct his answer by addressing a letter to the speaker. Even then, Mr. Maimane did not accept that to be true, and he continued to submit a complaint on the improper relationship between African Global Operations and the president's family to the public protector. Mr. Maimane had in his possession an affidavit by Mr. Pretorius, who made the payment and had said in it that the money was for the president's son. However, the investigation by the public protector revealed that Mr. Fenta was wrong on this issue. Now, the question that the public protector had to establish was whether, as she was requested by the complainants, the president had willfully misled the National Assembly. These were the terms in which the deputy president of the EFF had framed the complaint, and it was correctly framed in the language of paragraph 2.3a of the code. It appears from the report that the public protector accepted that the president was not willful. In one part of the report, the public protector recorded that the president's open code conduct referred to above, although in good faith, is inconsistent with his office as a member of cabinet, close quote. But instead of making the finding that the president did not willfully mislead Parliament, the public protector effectively changed the wording of paragraph 2.3a to include deliberate or inadvertent misleading of the legislature so as to cover the situation where willfulness was not established. On the basis of the changed code, the public protector concluded that the president, open quote, inadvertently and/or deliberately misled Parliament in that he should have allowed himself sufficient time to consider the question and make a well-informed response, close quote. The public protector was wrong to change the code. She could not have conceivably thought that willfully could mean inadvertently. These words are mutually exclusive. What she did went beyond the parameters of interpretation, but the finding itself is framed in terms that are concerning. The president could not inadvertently and deliberately mislead Parliament, because these two words cannot apply at the same time. It is either one or the other. Therefore, the public protector was wrong on the facts and on the law with regard to the issue whether the president had willfully misled Parliament, and the High Court was right to set aside her finding. The next finding is whether the president had a duty to declare CR17 donations and whether the public protector could competently investigate this issue. The public protector concluded that the president had improperly and in violation of the provisions of the Code and the Act exposed himself to a situation involving the risk of a conflict between his official responsibilities and his private interests, or used his position to enrich himself and his son through business by African Global Operations. There was no evidence supporting this finding. Instead, the evidence showed that African Global Operations donated 500,000 rand to the CR17 campaign. This cannot by any stretch of be interpreted to mean that the president used his position to enrich himself or his son through African global operations. Both the president and his son knew nothing about the donation. Even if one were to accept that the bank records relating to the EFG2 trust account showed that one of the beneficiaries was the Cyril Ramaphosa Foundation, this does not support the finding made for a number of reasons. First, the link between the EFG2 account and African global operations is the sum of 500,000 rand donated by the CEO. There was no evidence that the African global operations ever made a contribution to the funds in the EFG2 account other than this amount. Second, there was not a shred of evidence that African global operations or the president and his son had anything to do with the operation of that account. Instead, the evidence on record is to the effect that the president had no say and was not involved in the running of that account. This evidence was not disputed. Therefore, on this evidence, the president was not involved in the payments made from the EFG2 account to the foundation carrying the president's name. Under the same heading, the public protector also found that the president, as a presidential candidate of the ANC, had received campaign donations which benefited him in his personal capacity, and that his failure to declare those donations constituted a breach of the code. Once more, the evidence on record showed that the president did not personally benefit from the donations made to the CR17 campaign. The public protector may have not believed it, but she did not reject such evidence. Consequently, the matter must have been decided on the basis of that evidence. But more importantly, both these issues did not form part of any of the complaints submitted to the public protector. Therefore, she did not have the authority to investigate matters falling outside the complaints. This is a requirement of Sections 3 and 4 of the Act that empowers the public protector to investigate violations of the code. I shall move to the next finding, competence to investigate the affairs of the CR17 campaign. The public protector and the EFF argued that the High Court erred in concluding that the public protector had no jurisdiction over the CR17 campaign. The public protector contended that the source of her powers is Section 182 of the Constitution, together with Section 6 of the Public Protector Act. The EFF submitted that internal party elections constitute state affair because those party elections are a step towards legislative bodies. There is no merit in the argument advanced by both parties. Both the Constitution and the Public Protector Act do not empower the Public Protector to investigate private affairs of political parties. Political parties do not perform a public function or exercise a public power when they conduct internal elections. Theirs is a private affair and not a state affair. Moving to the investigation over the suspicion of money laundering. The public protector found that the 500,000 donation from the CEO of African Global Operations passed through several intermediaries, and this raised a suspicion of money laundering. But the evidence placed before her dispelled all this. The donation passed through only one account and not several intermediaries. The Audi principle. The president complained that the interim report in respect of which he was afforded the opportunity to make representations did not include the remedial action. He contended that he was entitled to a hearing before the decision on the remedial action was taken. The public protector countered this argument by submitting that Section 7, Sub 9 of the Public Protector Act obliges her to afford the affected persons a hearing only during an investigation. On a proper reading of Section 7, Sub 9, we concluded that a person against whom remedial action is taken is entitled to be heard on the proposed remedial action. We also held that the public protector had no authority to make the remedial action she had issued against the Speaker of the National Assembly, the National Director of Public Prosecutions, and the National Commissioner of Police. Amabungani's case. Once the High Court concluded that the code could not be read as obliging disclosure of donations made to political parties, it should have decided the constitutional challenge mounted by Amabungani. We find that the High Court erred in declining to decide it on technical grounds. That court should have decided the validity of the claim. In a dissenting judgment, Mokgwen CJ concludes that Mr. Musi Maimane lodged a formal complaint that allowed the public protector to investigate every aspect of the President's CR17 related conduct that she considered as potentially unethical. He holds that financial assistance from individual donors and even the composite amount from the CR17 campaign as an entity constitute a personal benefit to the President and creates a situation that involves a risk of conflict between the President's private interests, his pursuit of the ANC presidency with the assistance of private donors, and his official responsibilities as Deputy President of the Republic, Member of Parliament, leader of government business in Parliament, and even as President of the Republic. The President should, in his view, while still a Member of Parliament and Deputy President, have disclosed the sponsorship to the National Assembly as enjoined by the Constitution, the Members Act, and the Code. He further holds that the emails which the President effectively admits are authentic, true, and reveal that he deliberately represented a falsehood to the public protector. And this, together with his failure to disclose the private donations to his campaign, run against the very essence of his obligations laid out in sections 96 sub 2b, 83b, and 181 sub 3 of the Constitution, and the values of transparency, accountability, on which our democratic state was founded. In the result, the following order is made. 1. Leave to appeal is granted. 2. Save to the extent mentioned below, the appeal is dismissed. 3. The dismissal of Amabungane's Center for Investigative Journalism, NPC's claim for constitutional invalidity of the Executive Ethics Code is set aside. 4. The matter is remitted to the High Court for determination of that claim. 5. The President of the Republic of South Africa is ordered to pay costs of Amabungane Center for Investigative Journalism in this court, including costs of 2 counsel. 6. No order as to costs is made in respect of the other parties, including freedom under law. I hand down the judgment.
Please rise.
The court adjourns.